a lot of people have, and I think it's the view the juries often have, we do see a fair amount of guilty but mentally ill verdicts. We very rarely see, almost never, an insanity, a not guilty by reason of insanity. And perhaps part of the problem is the way we structure these defenses, and the fact that we don't tell jurors what's going to happen to a defendant for either of these two findings that they could make. So the other issue, of course, is he's charged with capital crimes, Dylann Roof. He faces the death penalty. He may well be also indicted federally for hate crimes, as I understand it from reading the newspaper. So he could be federally prosecuted as well as the current state prosecution. There's also other issues relating to sanity that would arise, for example, as whether he's competent to be tried, and also if he's found competent, if he's convicted, and if he receives the death penalty, which again, we're going way out in the future now, as to whether he'd be competent at some point to be executed. So, his mental state is going to be at issue at virtually every stage of this case, is my guess. I cannot imagine there's another legitimate defense they're thinking about, since he, as I understand it, admitted to premeditatedly going in and killing 9 people, 9 unarmed people.
Yeah, that's yeah, indeed. One last any closing thoughts, final thoughts you have, and I do want to touch on an element that we discussed to some extent actually in our last conversation, and that is whether or not jurors, individuals, lay people who do not have either a mental health background or a legal background, are the ones who should be making the decisions about sanity when it comes to a legal context. And any closing thoughts you have surrounding this case and other cases.
I'm so glad you brought this up again, James, because I think we ask too much of jurors to decide questions relating to legal insanity. I would prefer to see if people, now I'm sort of noodling around with this concept and I've been thinking about it for quite a while, but given how little most people know about mental illness and how suspicious they are of it as a defense, it seems to me that we have to really rethink how we decide sanity and insanity in the law, and that this is a really important place for expert advice, and possibly something like a 3-person panel to give at least an advisory opinion, a joint advisory opinion on a defendant's sanity. Now, the jury may still make the decision, but rather than having, this is a really bad place, I think, for battling experts, even though I'm usually a fan of battling experts in trial. I think this one really needs more thoughtfulness and more guidance. It would be the kind of, these cases I think would be helpful if we had a little more expert involvement earlier on, even as to decide whether or not to charge someone and take them to trial. I think that might make some sense. In other words, sort of diverting the prosecution, and if prosecution experts and defense experts can come to some agreement. Now, it's a complicated issue. It raises lots of constitutional questions, but the way we're doing it now doesn't seem to be working very well. So I'm hopeful we can rethink insanity going forward. Also, since we're developing more neuroscience evidence, but we may start to see at some point in the future, I don't think we're there yet, is we may start to see some really good neuroscience data to support claims of severe psychosis and things like that. That might be helpful for courts. So, we do have mental health courts for low-level crimes. I would really like to see that concept perhaps expanded to more serious crimes at some point.
One of the things that came to my mind as you were describing the non-adversarial process, what that might look like, is a concept that is gaining traction in family law that is in the area of what's known as collaborative divorce, where they have certain parties that are designated as neutrals, while each party has an advocate and they agree not to go to court as part of that collaborative process. There are individuals who work on behalf of the children and on behalf of the finances who are designated as neutral. They don't have a side. They're just there to basically call it as they see it so that each side can make a decision about how to proceed forward. I mean, and what came to mind is borrowing from that concept, a mental health psychoanalytical neutral that would serve the courts and defense, prosecution, and perhaps even the jurors.
I think this is a really good idea. Of course, the devil is in the details, right? There's certain experts who are known to be sort of pro-defense, certain experts who are well known to be pro-prosecution, and we see the same experts often in death penalty cases. But what would be really nice is if we had sort of a group of people who rotated consulting with the courts as, quote, neutrals, that both sides had to nominate and agree upon, right? And, we see this, for example, in arbitration, right? Each side gets to nominate people, and then they finally get a group they agree upon as arbitrators. This would be really helpful, I think, to courts. Judges, lawyers, jurors are not experts in mental health. They really need some help with this. And we really don't need a lot of lay people trying to sway jurors, I think, when they really don't understand mental illness themselves. So, yeah, any place we could bring in sort of helpful consulting experts to the court, I think we might get more rational outcomes.
Jane Campbell Moriarty, Carol Los Mansman Chair in Faculty Scholarship and Professor of Law at Duquesne University School of Law. It's always an absolute pleasure to talk to you, Professor Moriarty. You are just outstanding, and I'm a fan, and thank you so much for your time.
Well, thank you, Mr. Curtis. I am a huge fan of you and your show, and I love being on this, and I think these are great issues to talk about, and I hope we have more going forward.